Okay. Let's go ahead and start our closing arguments. Let me get my clock ready. How do you want to reserve your time by the plaintiffs?
Your Honor, we would like to reserve 15 minutes for rebuttal, and if we finish early with the first hour, and maybe use some of that on rebuttal as well.
Okay.
But definitely 15 minutes.
All righty. You may proceed.
All right, thank you, Your Honor, and as an initial matter, I want to thank you for your obvious, very intent focus on the case. And I know you're going to have some questions that you are going to be asking us, and we look forward to answering those. Let me tell you, the way we've divided this up. I'm going to talk about a couple of preliminary issues, and then jump into the terminal services agreement, and then and talk about the breach of that and the proper termination of that, and then Ms. Shee will address the transportation agreement. And some general issues at the conclusion of our opening hour. So I wanted to start. Oh, Your Honor, if we could get the screen sharing.
Oh yeah, just give me a second. Go ahead.
All right, I wanted to start with focusing in on what really is a fundamental question in this case, and that's whether ARM properly terminated the terminal services agreement and the transportation services agreement in March of 2021. And I focus on the right to terminate and whether that termination was proper, because there are certain things that flow from the termination. If ARM properly terminated, there are specific consequences. On the left, at the top, you see 6.04, upon termination, carrier, that's Medallion, shall immediately return all prepayment deposit and credit support provided by shipper without withholding set-off or other reduction. So that's a consequence of the termination of the transportation services agreement. As to the terminal
if the carrier has defaulted, correct?
Well, if the termination was proper, and the termination would be proper, yes, Your Honor, if the carrier defaulted.
Okay.
Right. And the same thing is in the financial assurances section of the terminal services agreement. They have to return the
under 6.04, there's a subsection A and B. Are you relying on A or B?
We're relying on B for this return provision.
Okay.
Okay. And subsection D of 14.3 in the terminal services agreement. These provisions also provide for the recovery of damages that were incurred during the period the contract was in effect. And we've presented evidence on damages during that period. But
let's turn back to 6.04B, okay?
Yep.
So it says if a carrier default has not been cured within 30 business days after receipt by carrier of a carrier default notice, or 2, if such failure is not reasonable. Am I reading the right thing?
Yes, Your Honor, you're reading the right thing.
Okay. Is not reasonably capable of being cured within 30 business day period, and carriers expeditiously commenced to cure the following its receipt of a carrier default notice, and diligently proceeds with such cure within such longer period of time as shipper agrees is reasonably necessary to cure such failure, then in any case shipper may, by written notice to carrier, terminate this agreement, any such termination to be effective upon receipt of the applicable notice by carrier. And then it talks about the remedies. And so do both sides agree that all of those things took place prior to the notice of default or notice of termination?
Yeah, I think that's where the dispute is.
Right.
Right. Again, Your Honor, I'm not going to address the damages during the period the contract was in effect, because I think you've made your views on that clear, and I mean, we're not abandoning it, but I'm not going to waste time on that. I'm going to focus. I'm focusing on the return of the prepayments and the letter of credit, which entitled, if we're correct, we get $32 million back plus prejudgment interest plus our attorney's fees. So the question then is, what do we need to show to establish that our termination was proper? Okay. And if we go to the next slide, it's proper if Medallion breached an obligation under either of the agreements. The obligation Medallion breached was material, and we satisfied the notice provisions, the procedures in the contract that I think were subject of discussion at the temporary injunction hearing. I think it's very important that we focus on the fact, as discussed in this next point. If you look at 13.3 of the terminal services agreement, there's a cross default provision and cross termination provision. And this is very important. It provides, if you look at it, that a default under one of these agreements provides a basis for terminating both of them. And Your Honor, this makes sense because I think you've heard that these contracts were essentially supposed to work together. You transport from West Texas to Corpus Christi, and then you're taking those barrels and you're transporting through the terminal to international markets to the extent that exercising that option makes sense. So to show that both of these contracts were properly terminated, ARM only needs to show a material breach of one of these contracts, Your Honor. And as I mentioned, I'll address the terminal services agreement and explain to you why we firmly believe that there was a material breach of that terminal services agreement. And then Ms. Shee will address the transportation services agreement.
Okay.
ARM has established a breach of the terminal services agreement because Medallion repudiated its promise or repudiated its obligation to provide ARM with Suez Max service. The terminal services agreement, we talked about it at length, that provides ARM with Suez Max service under section 3.4 of that agreement. Now, as I've listened to the parties argue and the witnesses talk about this provision, it's kind of interesting to me because I think there's been this rewriting of it by Medallion in a way to try to favor Medallion. And let me explain what I mean by that. When drafters, we see it all the time, when drafters put together contracts, they frequently speak in terms of the obligations that one party owes to another. And when they draft the contract in that way, there's an obligation on the one hand and there's a right on the other hand. Drafters also frequently establish rights and obligations by drafting it in terms of the right. And once they draft it in terms of the right, obviously there's a right and an obligation. Much of the discussion that we've heard in this case has been as if this provision was written in terms of what Medallion was obligated to do. The words in it were Medallion is obligated to do X or Y. As if it was written to say Medallion is obligated to supply capacity for a vessel of not more than 1 million barrels. And Medallion has relied on that sort of characterization of this provision to argue, well, that means we satisfy our obligation if we provide service of any vessel size that is not more than 1 million barrels. And I will tell you, Your Honor, we disagree.
So explain one of the things that's been really unclear to me during this, and I didn't draft this contract. I think that one of the things when I talk to young lawyers about who want to do transactional work is think very carefully about how you use your words. And a lot of the email correspondence before said up to or up, I don't remember the exact terminology, but basically up to $1 million. This says not more than 1 million. Not more to me means less, because what's not more, less. So it's not, again, not clearly written, but it says each of it, the capacity of less than 1 million barrels. That was written that way for a reason. I'm not sure why it would require a Suez Max based on the terms of the contract.
Well, I think you have to ask yourself, what is a proper exercise of either the right or obligation under this provision? And the provision, the way Medallion has argued it, it's as if this is saying Medallion is obligated to do X. The provision is not written that way. The provision is written as ARM's right. ARM has the right to nominate a vessel not more than 1 million barrels. And if ARM, nominates a vessel of any size that is not more than 1 million barrels, it is properly exercising its right under this contract. And as a result, Medallion has an obligation to honor that nomination.
So was there ever a time where ARM nominated a berm loading vessel during the time the contract was in place? Did they ever actually nominate a vessel? I don't recall that they did.
Yeah, they definitely nominated vessels. They were consistently told that, you know, you couldn't nominate more than an Aframax capacity vessel. And very frankly, ARM and Glencore, you know, were responding to Medallion and Epic saying, look, well, it's going to be done by June. Well, it's going to be done by the third or fourth quarter. Well, it's going to be done next year. And then ultimately, right before we terminated, they said it's never going to be done. Okay.
But I think I don't know what I was asking. Did they ever actually nominate a vehicle or nominate a berm loading vessel?
Yes, they did.
What exhibit is that? Did they ever nominate a Suez class or Suez Max vehicle?
They couldn't.
Did they?
No.
Okay.
They did not.
But they nominated Aframax.
Yes, we saw the testimony of one of the witnesses that they nominated Aframax and sent it to South America.
Okay.
I don't know if you recall that. So, Your Honor, we think it's just clear and unambiguous that the right that we were given was the right to nominate a vessel of not more than 1 million barrels capacity. And anything under 1 million or 1 million or below would be a proper exercise of our right. And there's nothing in this provision that limits that right to some reasonable capacity of vessel in Medallion's discretion or Medallion's limitations, whatever. It is a firm entitlement, unambiguous entitlement that we have to properly nominate 1 million barrels capacity or less.
Okay.
And you know, and essentially Medallion's interpretation would require adding words to the contract that aren't there. It would require adding, after you read the sentence that's highlighted, Medallion can limit ARM's nomination to a specified vessel capacity so long as the capacity is any volume less than $1 million and 1 million barrels. And there's nothing in this provision that makes that limitation or any limitation on this right that ARM had. And our interpretation is supported by all of the objective evidence surrounding circumstances, particularly where everyone involved, contemporaneous documentation shows that they all agreed we were getting a Suez Max vessel. Now, I don't know how serious they are about this, but they have also argued that not more than 1 million barrels of capacity refers to terminal capacity and not the capacity of the vessels that are to be nominated. And that, frankly, makes absolutely no sense. 1 million barrels of what? The capacity of a terminal is measured by its throughput and potentially by its storage. And throughput capacity and storage capacity, the capacity of the terminal, is specifically addressed elsewhere in the contract and has nothing to do with this nomination under 3.4. Now, I thought it was interesting. I think the court focused in on the fact that in the mirror agreement that Medallion had with Epic, there was a commencement date for a new terminal. And the commencement date in our agreement with Medallion had a commencement date that was estimated as opposed to firm. You recall that, Your Honor? It was a June 1 date in the Medallion contract with Epic, and it was an estimated date in ours, an estimated date of June 1. And I don't know if Medallion is continuing to rely on that as somehow meaning that the occurrence of a commencement date, that the fact that a commencement date never occurred means they never had any obligation under this. I don't know if they're going to make that argument, but if they do, it has absolutely no merit for two reasons. First of all, this right to nominate not more than 1 million barrels that ARM had applied to both of these terminals, not just this new terminal. Second, the contract clearly contemplates that a new terminal would be built and would provide services under the term of this agreement. And you see that, Your Honor. I've got some examples on this slide. It's you see it on the very first page of the contract in the whereas clause, whereas Epic Crude Terminal will construct, own, operate a crude oil terminal facility located adjacent to the initial terminal. In the definition of delivery points means the outlet flange of the initial terminal or new terminal as applicable. Epic Pipeline means the pipeline being constructed by Epic Crude Terminals affiliate for the purposes of transporting crude petroleum from near Orla, Texas to the initial terminal and new terminal. Firm basis means a service level that is higher in priority than the service level for any other person who contracts for the same service on a non-firm basis at the new terminal and initial terminal as applicable, and is not subject to curtailment or interruption except in the event of force majeure. Terminals, as used in the agreement, means collectively the initial terminal and the new terminal. And then we've got interconnections, which specifically creates obligations with respect to the new terminal. Operational standards, same. Operating hours and marine docks, same. And then the vessel nomination in paragraph 1 to nominate a berth at the initial terminal or the new terminal. So this contract contemplates service at both the initial terminal and the new terminal. And for that additional reason, the absence of a definite commencement date is not, or for the new terminal, does not somehow excuse Medallion from performance. And in particular, it's black letter law that where a contract does not specify a specific definite time for performance, a reasonable time is required. Under the Heritage Residence versus Anschutz Corp case cited here, quote, when no time for performance is given in a contract, the law will imply that the time of performance was to be a reasonable time. The absence of an express time for performance does not necessarily mean that the parties did not enter into an enforceable agreement. Generally, the law will imply a reasonable time. Now, I will say a reasonable time does not mean never. And we know that a month before we terminated this agreement, Medallion told us in no uncertain terms that that terminal would never be built. This is a repudiation of the contractual obligation that led directly to the termination a month later. Now, Medallion has also relied on Exhibit B as somehow negating its obligations under Section 3.4. And that's the exhibit that talks about the Corpus Christi requirements and Epic's various specs or limitations. And it's sort of a do loop. I mean, the only reason the exhibit—
It's sort of a what? You said do What's a do
loop. It's sort of, it's a loop that just keeps going.
A loop. Okay, I'm sorry, I didn't hear you correctly.
I'm sorry. The only reason Exhibit B requirements could not be met is because Medallion and Epic didn't perform and supply the Suez Max capable docks they agreed to provide. It's just nonsense that this would excuse them. You can't negate your agreement to provide something because your failure to provide that something prevented you from meeting certain standards you would have satisfied if you'd done what you were obligated to do. That's the do loop. It violates the most basic principles of contract construction to suggest that they can get out of it, their obligation on that basis. And not only the basic rules of contract construction, but even in the agreement itself, they said if there's some sort of a conflict between the exhibits and the agreement itself, and the body of the agreement, the body of the agreement controls. Now, Your Honor, you've also raised the issue about who bears the risk, and very specifically with respect to the terminal services agreement. We all know that Medallion's ability to perform on its contract with ARM required performance from Epic, right? I mean, Epic had to build the dock. And I think it's the fact that Medallion's was dependent on Epic doesn't mean that Medallion wasn't responsible for the express obligations it assumed to ARM. This is not, I mean, we all know, we've seen these kind of back-to-back contracts before. Medallion had a contract with Epic. Epic was going to perform obligation, or undertook obligations to Medallion, and then back-to-back, Medallion turns around and says, all right, these obligations are going to be performed, and we will commit to you in your agreement with us that they will be performed. And that's not an unusual arrangement at all. As you can see from this, just the point is that the agreement that we had between ARM and Medallion, not Epic, and it was Medallion that owed obligations directly to us. Now, I want you to think about the back-to-back nature of this and how it all works together. Because Epic owed obligations directly to Medallion, if Epic failed to perform, Medallion would have a cause of action and a right to sue Epic. If Medallion fails to perform for us, we have a remedy by suing Medallion as we're doing here. It's sort of a daisy chain. We go against them, they go against Epic. And if you think about it, if we aren't, if we are somehow, if Medallion is somehow not at risk, we would have no remedy for breach of this contract. Medallion can sue Epic. Here is the terminal services agreement, Your Honor. It's Exhibit 20, I believe, Defendant's Exhibit 20, between Epic and Medallion. That contract says that that there are no third-party beneficiaries for that contract. That means that Medallion is the only party that can sue Epic for the breach. And Lord knows, why they haven't, or if they, I mean, they've certainly preserved their rights, and their CEO didn't know whether they'd actually sued Epic or asserted a claim. But this is their remedy. This is how they protect themselves from an Epic breach. We, in turn, have our contract directly with Medallion. And the only way that we can protect ourselves is by suing Medallion, because we cannot sue Epic because we're not third-party beneficiaries under this contract. And in our contract with Medallion, you know, this was implicitly acknowledged. If you looked at 14.4 of the Terminal Services Agreement, it states that at the bottom of this paragraph, it contemplates that Medallion might have to sue Epic for a failure to perform. It states at the last sentence, customers shall provide reasonable cooperation and assistance to Medallion in the event of any dispute or litigation between Medallion and Epic Crude Terminal arising out of the TSA, which is the defined as the Terminal Services Agreement between Medallion and Epic, and affecting or relating to the services and other obligations of Medallion hereunder. And another interesting thing in this provision is it recognizes that to the extent we're dealing with Epic directly, that ARM is dealing directly with Epic, if you look at the first sentence, it's because Epic is performing the contract as a designee of Medallion, as Medallion's designee. So Medallion here is saying it's responsible for what Epic does. And that's the only thing that makes sense. And if there's any doubt from a legal matter, we've got plenty of cases, but here's one, Chevron Phillips versus Kingwood, that makes it very clear that when a party like Medallion contracts to render a performance or produce a result for which it is necessary to obtain the cooperation of third persons, it's not excused by the fact that that third person, like Epic, won't cooperate or perform. So in sum, Medallion had an obligation to ARM under the services agreement to provide Suez Max service. That obligation was repudiated in breach of the agreement when Medallion informed ARM on February 9, 2021, that the terminal services agreement would never be built. So there was a breach. The question is, was it material? And I think the answer is unquestionably yes. Here's a standard for materiality. Ms. Shee will go into this in a little bit more detail, but I'd like to focus on a couple of things. First, remember that these two contracts, the Transportation Services Agreement and the Terminal Services Agreement, really worked together. I mean, you know, you got the cross default provisions. They were executed at the same time. They reference each other, and Your Honor, they mesh together if they're properly performed, because we had the right under the Transportation Agreement to transport approximately 860,000 barrels during a given month. And at the terminal, if we aren't given Suez Max capacity, which is or capacity above Aframax, there's a mismatch.
What is the most number of barrels that were shipped in a particular month?
So I don't have that off the top of my head, but I do know that Glencore paid pump over fees. So there was oil, and we heard that, I believe, from Mr. Wishoff.
And pump over fees is if they went over 750?
They went over the 750 and they had to send it somewhere else. So there was a mismatch. And Your Honor, again, I can't emphasize enough. We're talking about, I know you're focused on what actually happened, and that did actually happen. But this is a 5-year contract. The premise of it was you do have these two contracts that work together that are going to give you the ability to ship over WTI or WTL overseas to the extent it makes sense. And there's just a mismatch if you do not give the ability to ship at least 860,000 barrels a month. And it's going to create costs that make it uneconomic. And frankly, I think you see that from, and it's a 5-year contract. I mean, we're just a year into a 5-year contract, and they are telling us they are not going to do this going forward. Now, there's been much made about,
You've used 30 minutes.
Okay, I'll go a little bit faster and get it to Ms. Shee. Much has been made about the collapse in spreads between West Texas and Corpus Christi during COVID and during the period this contract was in effect. That spread actually absolutely did collapse. There's no guarantee that that would continue for the full 5 years of the term. But I think to the extent we're talking about the Suez Max capacity right now, unquestionably it was material. If you look at Glencore, which was the expert on shipping crude to international markets, it had, as you recall, absolutely no exposure to the collapse in spread. No exposure. Yet it participated in the termination of the contract with ARM because it did not get the part of the bargain where it was going to profit. And that was the shipment of crude, the 860 plus efficiently to international markets with the assurance of a Suez Max capacity vessel. The objective evidence confirms materiality. We have emails that are in evidence where they talk about the mismatch. These are emails between Medallion and its private equity sponsor, where they're recognizing the mismatch and talking about its importance, and that getting the Suez-sized vessel was an important part of the deal. You had Medallion's own expert witness talking about how important a Suez Max was to shipping to international markets, testifying that if you didn't have Suez Max, you'd have to go to more local markets. So just in sum, before I pass it to Ms. Shee, we believe that the contract clearly and unambiguously required them to provide Suez Max capability. They repudiated that obligation. That obligation was material. And as a result, having provided proper notice, well, first of all, we had the right to terminate both of these agreements on the basis of that repudiation and breach. So I'll pass it to Ms. Shee.
Ms. Shee, you have 28 minutes.
Thank you, Your Honor. Your Honor, I'm going to talk about the WTL promise. And just to briefly go over the contracts, the terminal agreement, the transportation agreement spells out that Medallion will transport crude petroleum as defined in the Medallion tariff, which in turn, you see, agrees that Medallion is going to transport, shall accept for transportation under EPIC's Permian Common Stream 2, the crude petroleum, pursuant to the quality specifications of the EPIC rules and regulations tariff.
Ms. Shee, let me ask you a question. This is kind of probably not exactly what you're talking about, but let's say that I find that there was a material breach, for example, where they didn't provide the Suez Max capacity, but I find there's a breach there, but not a breach for the WTL. What would your damages be? Would they be the same, or would it change the analysis? Do you have to have both, or can you have either?
It would be exactly the same, Your Honor. Under the contract, in the event of default under one of the contracts, there's a cross default provision under 13.3 of the terminal agreement that makes a default as to one, a default as to both. And at that point, the remedy for that default is simply return of the consideration, which is the prepayments and the credit support. That's $32.7 million. And so you only need to find one to get there. And it's not really damages, it's really just a return of a down payment and credit support.
Okay.
And the EPIC tariff clearly spelled out WTL. I don't think there's any dispute about that. Permian Common Stream 2 is WTL, and it said it was going to take it from groups 1 to 3. And there is nothing on the face of this tariff that suggests any qualification as to taking WTL, at least until December of 2020, which is 8 months into the contract. Now, Your Honor has heard testimony, and Medallion has acknowledged that there's an obligation of truthfulness in a tariff. It needs to spell out the services that you're actually going to provide, and then you need to provide them. And for that reason, and you've heard testimony about this too, most carriers treat a tariff as a floor for the service they're going to provide. They kind of under-promise and over-deliver. It's sort of the baseline of what they will do, but then they'll also go off spec to accommodate customers to the extent they can. And here what you have with Epic, and by extension Medallion, which took on Epic's obligations as its own, you have kind of the exact opposite. You have Epic over-promising and under-delivering in its tariff. It said black and white in this tariff, it is going to take WTL from groups 1 to 3, and yet it didn't do it. And again, we've looked at these origin points, and you've gotten a long list of excuses from Medallion about, why WTL was not coming in through these points, but they're not coherent. And again, I'd invite you to look at the actual tariffs and just see, construe them on their face and see if there is any indication in these documents that WTL isn't being provided, because I will tell you there is not. Despite that, and again, we saw this in opening, Medallion and Epic did not provide WTL service from any of these origin points while the contracts were being performed. And they've given a whole list of excuses. And I call them whoppers here, and I hope that's not too flippant, but it's just flat out wrong. We heard from Mr. Lentz that gathering systems only take one type of crude. It's false. We heard that no WTL was available at Epic Interconnects. It's completely false. We heard that Epic has no tanks to facilitate batching. Again, their tariff suggests otherwise. Their tariff spells out otherwise. He says a 2,000 barrel per day nomination would just blend away. Again, no, that's not how these batching operations work. And we'll talk about this in a bit. And there was also this allegation that it was Salt Creek's fault. So let me just start from basics. There was this implication that WTL was somehow rare or hard to get in this area. This is not a niche product. This is Plains, which is a competitor to Epic. This is a presentation that they gave in 2019.
No, I don't think this is in evidence.
Is this an evidence or not?
It's not. This is just a demonstrative, Your Honor.
It's not a demonstrative. It says Plaintiff's Exhibit 39. You need to take it down.
You heard various admissions from witnesses that there is plenty of WTL in the Delaware Basin. It is actually the predominant product out of the Delaware Basin, which is in the westernmost part of the Permian Basin. And on the topic of gathering systems, Mr. Lentz's own employee impeached him in his testimony. It is clear that gathering systems can handle more than one type of crude. Mr. Witt agreed they can handle both WTI and WTL. And you heard from Mr. Wishoff this morning that WTL was available at multiple gathering systems connected to Epic. It was available at Salt Creek. It was available on the Delaware Express. It was available at Gibson Wink. I apologize. All of these places, and probably more, these are just out of Mr. Wishoff's personal knowledge, had WTL at the time the contracts were being performed. Now,
I guess my main problem here, Ms. Shee, and I've been thinking about this quite a bit, is that when Epic changed its tariff, they had, according to the depositions, and I'm sorry, I don't remember who, they had, I think it was 30 days or 14 days to object to the change of the tariff when Epic said they were no longer going to accept WTL, and they never objected. And so is this something they were even going to do during the time of COVID? I just don't find that very persuasive.
Your Honor, there's a few layers to that. First of all, that change didn't become effective until 8 months into the contracts. So that is 8 months where Epic is saying it's going to transport.
But during those 8 months, did they ever attempt to nominate WTL?
Well, they were repeatedly being told that the service was not available. And there's a robust doctrine of futility under Texas law that, if you're being told not to do something, if you're being told, do not nominate this, it is impossible, you're not required to do it as a precondition. It would have been a performative exercise.
But didn't they also say, like, hey, if you have a problem with this, let us know?
And we did, and we reached out to Medallion. And again, the email.
When did you reach out to Medallion? It was after they had changed their tariff and you guys had an opportunity to object, and your CEO wasn't even looking at he was getting, I think it was CEO, I may have the position wrong, but he was getting notifications about the change in the tariff. He wasn't even reading them, and the person in charge of it didn't think it was a big deal. So I just don't see how. I will say I'm looking at these very differently. I think this whole thing with WTL really feels pretextual to me. So anyway, go ahead.
Just to talk about the sequence a bit, the email, I think we're talking about two different communications from Epic. The first one came on April 3rd, which is 3 days into contract performance. And they reach out and they say that they're suspending WTL service. It's just an email. It's not a tariff change. And we promptly raised that with Medallion, which was our counterparty. Epic wasn't our counterparty. We raised it with Medallion. And Medallion said, you know what, sit tight. It's going to come in June. And it didn't come in June. And it didn't come in July or August or September or in October. What did come in October after we sent a demand letter about WTL was a suspiciously timed change to the Epic tariff. Now, unfortunately, our president did miss the email notification from Epic, but again, there was no notification from Medallion, which was our counterparty. It was on Medallion to tell us about this change, and they didn't tell us.
But weren't you relying on the Epic tariff?
We were actually relying on the Medallion
in order for you to ship it, it would have to be on the Epic tariff, right? You knew that Medallion did not own these pipelines. You knew. I mean, at least seems reasonable to me that your CEO or whoever was in charge of this would be monitoring the Epic tariff. And if there was a change, it was so material that it would cause this massive loss, they would have raised some type of objection.
Well, frankly, we were surprised that Medallion didn't raise an objection. And I know you've read the testimony.
But you guys had never nominated, you never attempted to nominate. I mean, it seems like during the entire time this contract was in place, there was only one nomination made, and it was for 2,000 barrels a day, right?
Correct, which adds up to 60,000 barrels a month, which is
but it's only but you had the right to ship up to 27,000 a day, right? Barrels.
That is correct.
So but this again, is, I mean, 60,000 is a lot, but when you're trying to fill a Suez Max, I mean, I assume that these tankers, I don't know that we've ever heard testimony, you can't do them partly WTL and partly WTI, or maybe you can. I don't remember hearing anything about that, but that was only 60,000 barrels. How would that even be shipped?
You actually can ship a combo cargo, it's called. It's in Guy Freshwater's deposition. You can ship, you know, some of one, some of another. And the 2,000 barrel issue is, this was done because Medallion told us, look, yeah, they can't take WTL, but you need to paper this up. But to actually nominate a product, you need to purchase it.
But did you guys even have, at this, did you even have access to WTL?
Yes, absolutely. Mr. Wishoff testified on his direct, and again today, that ARM was buying WTL and shipping it on other sources, and it would have gone into Epic had Epic been able to take it.
When was WTL shipped on other sources?
It was throughout the contract period.
Okay. Go ahead.
And on this topic of the 2,000 barrels per day, it's entirely consistent with what we bargained to do, because you put those 2,000 barrels into what's called a common stream, which is an aggregation of other parties' product. And again, this goes, the 2,000 barrels a day equates to 60,000 barrels a month. And it goes into this common stream where it is commingled or intermixed with product of like quality and characteristics. And here's how this all works together. Under the tariff, and the highlighted part should be here, point 2C, the carrier will provide all required facilities and service, including operational storage, to accommodate receipt and delivery of the common streams. That's really important. The operational storage, these tanks, that's how this all works. You batch different kinds of crude because you have your nominations, your 2,000 barrels per day or whatever coming in, and they all get aggregated in a tank together. And when they reach critical mass, they go down the pipeline. And again, like the EPIC tariff specifically says that it's going to provide operational service to facilitate this batching. It is part of the deal that they signed up to do, and that Medallion by extension signed up to do. And again, we looked at this graphic this morning, but these tanks are explain exactly what's supposed to happen with common stream. You get small amounts coming off of the gathering system, you aggregate them in a tank, and when it reaches critical mass, you release it from the tank and you can batch it down the pipeline. So this notion that it would have been physically impossible to transport WTL is just, it's unfounded. The EPIC tariff spells out exactly how it's going to be done. And I'm not sure how much of a live issue this is anymore. There's been some suggestion that the lack of WTL was somehow the fault exclusively of Salt Creek's interconnect. It's just been disproven. If anything, it is EPIC's problem, because EPIC was so late getting to Salt Creek that EPIC's production, that Salt Creek's production ended up going into a competitor pipeline because their producers had to find somewhere to go. Oops. And Mr. Lenz, sorry, was forced to admit this during his testimony, that he had no personal knowledge to the contrary. Here's a really important point. On line fill, and you've heard Medallion say there wasn't line fill. You probably read Mr. Burney's deposition that there wasn't line fill. The responsibility for line fill was Medallion's, full stop. And you heard Mr. Wishoff testify today, line fill is expensive. But that is not our problem. That is Medallion's problem. If EPIC was having trouble lining up line fill, that is ultimately Medallion's problem. And we don't really know. Honestly, we don't know why EPIC was not transporting WTL. We know there was supply. We know there was supply coming off of gathering systems. We know it wasn't transporting it for customers then. We can theorize that they didn't want to shell out the money for the line fill, but we don't know. But at the end of the day, it's not ARM's problem. The fact that Medallion didn't perform, the fact that EPIC didn't perform is Medallion's problem, because Medallion took on EPIC's obligations as its own under these contracts. And Medallion, just to remind Your Honor, Medallion is not asserting an impossibility defense. It never has. It is specifically disavowed it in its interrogatories. So for whatever reason, EPIC wasn't performing. That is on Medallion. You heard in opening this idea that committed firm service has, only obligated a Medallion to transport whatever EPIC was going to do, whatever EPIC was actually doing, and that's just false. Committed firm service just means that you are first in line if the pipeline is over full. You're not going to get bumped. It's kind of like being on the airlines. If you're like a platinum traveler, it has nothing to do with tying you to certain service. Okay, and Medallion, just to be clear, there's been the suggestion now that WTL service we were somehow indifferent to. Again, look at this email from when the contracts were being negotiated. Mr. Lastman specifically recognized that ARM would not have done this deal without this product. It was that important to ARM. ARM had a business focus in the Delaware Basin with these lighter barrels. This was what ARM got into it to do. And as we talked about a few minutes earlier, ARM was in fact out there, selling WTL to other pipelines because EPIC wouldn't take it. And our experts explain the materiality of WTL service. Oil prices are volatile. WTL and WTI are two entirely different products, and they have different markets, and the prices fluctuate all the time. And sometimes you can make a better margin on one and sometimes on another. And as a general matter, the WTL discount in the Permian Basin is more than the WTL discount abroad. So it's an important opportunity to make money. And if you cut off WTL service, you cut off a potential area to make a little more margin or a lot more margin on your barrels. It really can affect the economics of the project. And Medallion's expert actually acknowledged this. He said it's an attractive barrel. It's a profitable source of crude. It would have attraction to customers. We're not making this up. He said there's a robust market for it. This is their expert, not ours. This is not something we dreamed up. This is an important product that we specifically bargained for, that we would not have done this deal without. And I just kind of want to orient the court, and this combination, the Suez Max and the WTL, they're actually very complementary services, because you're supposed to have the option to pick one of two grades of crude and go to multiple markets. You can go to Europe, you can go to Asia, you can go to Latin America. And again, you heard Medallion's expert agree that if you only have if you only have a Suez Max, you're going to get to Latin America. And if you only have one grade of crude, then you're missing out on an entirely different potential revenue stream. It's really kind of cutting off the deal that we thought we were going to get. It significantly diminished its value. And Your Honor, that is all I have on the WTL point, unless Your Honor has any questions.
I think I've asked them. Are you going to argue damages at all?
Your Honor, our damages, as Mr. Stern said at the outset, are,
I guess, countering their damage argument, or did you want to wait for rebuttal on that?
I can touch upon it very briefly, and then we can come back to it in rebuttal to the extent you have questions.
Okay.
Their damage model does not account for the time value of money. $100 today is worth more than $100 5 years from now, because you have that $100, you can invest it and make profitable use of that money. Their model ignores that. They've sort of messed with discount rates in order to jack up the amount they claim they're entitled to. And really, if they're entitled to counterclaim damages at all, if you use an honest application of discount rates across, their various categories, it gets you to under $2 million, as low as, I think, 57,000 was what Dr. Jacobs said. And that's just, it's solid economics right there.
Okay. Do you want to reserve the rest of your time?
Yes, Your Honor. Thank you.
All right. You have a total of 24 minutes left. Let me restart. And we can start with defendants. Are you?
Yes, Your Honor. There are two facts that impact almost everything else in this case. The first critical fact is that these contracts were entered into before COVID. COVID dramatically changed the economics of the deal. The second critical fact is that these contracts were for capacity that was controlled by a third party.
Can I tell you I'll just lead
Yes.
with what my major concern is here. And I think it was, there's two potential breaches here. One, I think is pretty unclear. The other one, I think the argument that when Epic said we're never going to build the initial terminal, I don't know how that's not a material breach under the contract. And so and if there's a material breach, I think you have to return the credit, the 37 million. That is, to me, kind of where my mind is stuck. So if you want to talk about that issue, I get the COVID stuff. I've heard all the argument. How do you get beyond that?
Yes, Your Honor, if we could look at Defendant's Exhibit 4, and in particular, paragraph or Article 3.4a of this agreement.
Mm-hmm.
So several things on this, Your Honor. First of all, the provision that ARM continues to point to, which is this first sentence of Article 3.4a, has a clause in it, a parenthetical clause, that is not in the agreement between Epic and Medallion. And that is, starting on the fourth line down, subject to the occurrence of the commencement date for the new terminal. It's not just subject to the commencement date for the new terminal, it's subject to the occurrence of the commencement date for the new terminal. These contracts, the contracts the Medallion had with Epic and with ARM, are not back to back. And the changes that were made in these contracts specifically go to, as in this case, circumstances where we don't control, Medallion does not control what Epic does or does not do with building a new terminal. You can't.
But surely I understand that argument that there's some flexibility that they did. If it, say, for example, it wasn't built in May and it was built in June, I get it. But when they said they're never going to build it, there has to be some reasonableness here, and it doesn't say the commencement date can never happen. There's going to be a new terminal according to this contract. And then when Epic said there's not going to be a new terminal, how do you get beyond that argument?
Let's look at, Your Honor, I'll show you slide 45 from the slide deck that I've prepared. I'm glad you pointed me to what you're most concerned about, because as you can see, it was later in my slide deck.
Okay.
So this is the relevant portion that Mr. Stern alluded to from the email, which is February 9th, 2024. There is absolutely no evidence that Epic said it was never going to have a new terminal. And in fact, this email, which Mr. Stern pointed to as being the email of breach, and as being the email where Medallion said the new terminal was never going to be built. Look at point 2B. When the second dock is complete, expected third quarter 21, they will have the same.
Has the second dock been completed?
The second dock has not been completed. The Epic has the project paused. The second dock is also not material as of the time of breach, Your Honor, because we could talk about this mismatch argument, which I think is essentially what the plaintiff is going to with respect to the second dock. And moreover, we need to talk about the absence of a nomination. We need to talk about what is actually allowed to happen at the initial terminal and the new terminal. There is no meaningful distinction between the two terminals in terms of what ARM gets a right to. So let's go back to slide 30, Mr. Spalding. So let's start here. It was plain on the face of the agreement that the initial terminal was an Aframax terminal. All right, you have to multiply the loading rate times the allowed lay time to see that it is for loading 720,000 barrels on a ship. ARM does not have a right to send in a ship and have it sit there for more than 36 hours. The lay time, maximum lay time, is 36 hours. And in fact, if we go to slide 31, Epic told ARM and the other shippers that the initial terminal was going to be Aframax capable. This is before the execution of the terminal services agreement. If the parties had intended to give ARM a right to load a Suez Max vessel at either the initial terminal or the new terminal, they could have expressed it exactly that way in the agreement, but they did not. And it would not have made sense, because not only was the initial terminal going to be an Aframax terminal, but the dredging project was not complete, which constrains both terminals because they are adjacent to each other. If we go to the next slide, since there is no language giving ARM a right to a Suez Max Suez Max loading, the word Suez Max is not in here. ARM has always relied on this sentence of Article 3.4a to argue that it should be able to load 1 million barrels on a ship. And that's where they kind of get to the materiality of the new terminal. They say, well, if we got the new terminal, we could load 1 million barrels on a ship. But as Mr. Stern admitted, this provision gives a right to nominate, and it gives only a right to nominate. The loading requirements are addressed by other provisions, including the loading rate provision that we just looked at. Under Article 3.4a, the right to nominate is either at the initial terminal or the new terminal, and the sentence advises ARM, warns ARM that each of the terminals, the initial terminal and the new terminal, will never be able to load a ship with more than 1 million barrels. Through the term of this agreement, in the constrained space of the inner harbor, each will have a capacity of not more than 1 million barrels. ARM's argument around the text of this sentence requires rewriting Article 3.4a to make it about loading and not nominating, and to try to have the 1 million barrel language modify vessel instead of the terminals. The issue is whether, if we go to slide 35, The issue is whether this last clause, each with the capacity of not more than 1 million barrels of crude petroleum, modifies ARM's entitlement to nominate back there at the beginning of the sentence, or whether it provides a description of the vessel capacity for each of the terminals referenced in the immediately preceding clause. As a basic rule of grammar, relative and qualifying words, phrases, clauses are to be applied to the words or phrases immediately preceding and are not to be construed as extending to others more remote. In other words, each with the capacity of modifies the initial terminal and the new terminal, not the vessel. It's the only reading of the contract that comports with physical reality as well. If we look at slide 39, it is uncontroverted that the inner harbor channel is not deep enough to load 1 million barrels on a vessel at either terminal. ARM itself told a customer this back in 2018. ARM told its customer that the harbor would have to be dredged in order to accommodate fully laden Suez Max tankers. Mr. Barney's testimony also makes this clear. He was asked, will governmental authorities have provided the required clearances? He says no, because of the depth, it would ground the ship. Mr. Freshwater of Glencore, he also agrees. He says that he's not aware of any inner harbor location where a Suez Max vessel could be fully loaded to 1 million barrels because they're all subject to the 45-foot draft restriction. The physical impossibility of loading 1 million barrels on a ship in the inner harbor of Corpus Christi is a sort of objective surrounding circumstances the court can consider when construing the contract. So ARM is wrong when it argues that it has a right to load a Suez Max or a 1 million barrel vessel. But it is also worth noting that ARM is asking the court to decide this issue in the abstract, not in connection with the particular vessel that ARM or Glencore did not get to load. In order for there to be a breach that would support termination under the contract, there must be an unreasonable rejection of a nomination, and it must be as well, and we'll get to it, a material breach. So let's look at slide 43 and talk about Exhibit B. Now, Exhibit B is part of the contract, and in fact, there is a provision, Article 3.4C in the contract that says that the right to load is governed by Exhibit B. And a breach can only be assessed in connection with Exhibit B and in connection with the handling of a nomination. Medallion and Epic have the right to refuse approval of a proposed nomination notice, and the reasons for rejection can include the vessel nominated. In that situation, the court would have to decide whether Medallion or Epic unreasonably withheld, conditioned, or delayed approval of a nomination. ARM has suggested that if it did not receive a firm 1 million barrel loading right, then Medallion or Epic could turn it down even if it pulled up to the terminal with the rowboat and a barrel in the back. That's silly. Medallion and Epic cannot unreasonably withhold approval of a nomination, and the agreement makes clear on its face that the terminal can load 20,000 barrels per hour and that Epic will allow 36 hours of lay time to fill a vessel. Dealing with a nomination is Medallion's or Epic's responsibility, but there cannot be any breach until performance is due. In other words, when a nomination is actually made. There was not any unreasonable rejection of a nomination here, and in fact, there was not any rejection of a nomination at all. Under Article 3.3C, in addition to being able to reject or accept a nomination, Medallion can also exercise commercially reasonable efforts to accommodate and revise or cause to be accommodated and revised nominations submitted by a customer. So if we go back to slide 45, which we've looked at before, when in response to Glencore wanting to load a larger ship, in January 2021, Epic offered a pump over to Pin Oak, which is a little bit larger dock. There was no response from ARM or Glencore. It does not say that the new terminal is not going to be completed. It says that it will be completed in 2021. Is now ARM's position that this letter constitutes a breach. I'll just note that this is about 4 months after the October letter that until now they've claimed is the notice of breach. And there is no letter from ARM between this point and the point where the parties both sent termination letters to each other.
Let me ask you kind of more fundamental question. If I do find that there is a material breach on either of these two, WTL or the Suez Max, do you agree that the damages would be what the plaintiff has stated, or the remedy would be the return of the credit support?
Your Honor, there is a cross default provision. So that is correct, Your Honor.
Okay.
There is another way, Your Honor, that ARM does not grapple with the realities at the port of Corpus Christi, which is specifically, they haven't grappled with the fact that it is the port, the governmental agency, that controls the loading. Exhibit B, again, shows that the port of Corpus Christi handles the nomination notices. The port of Corpus Christi must give all required clearances, and the port must designate a safe berth for the vessel. And under the contract, all vessels will be dimensionally acceptable and meet all requirements of Medallions or its designee, Epic Crude Terminals, Wharf Facilities, and governmental agencies. It is undisputed what the requirements of Epic's wharf facilities were. Those requirements were shared with ARM in the Epic Port Manual, which is Defendant's Exhibit 191. The maximum size ship was an Aframax ship in the port manual. Whether or not the new terminal is built, it doesn't give ARM any more loadings per month. They still have a right to one loading per month, 36 hours, pursuant to a port manual that is issued by Epic, and still subject to the requirements of governmental authorities for loading, including the dredging restrictions in the channel. The agreement, as we looked at before, makes clear that the initial terminal was going to be an Aframax terminal. Epic told the public, including Medallion and Epic, that the new terminal would be Suez Max capable, which is not the same as being able to load a Suez Max, because again, you have the restrictions of the depth of the channel. Regardless, full loading of a Suez Max would not be available until the inner harbor was dredged. But if we look at the back at 3.4a in slide 49, services begin with the initial terminal commencement date. The entitlement to nominate begins with the initial terminal commencement date. And Medallion had no control, as I mentioned before, over whether Epic was going to complete construction of the new terminal. There are differences between Medallion's agreement with Epic and Medallion's agreement with ARM that address the fact that Medallion did not have control over whether the Epic finished building the new terminal. So we look at the next slide. The Epic Medallion agreement does not have the phrase subject to the occurrence of the commencement date for the new terminal. That is conditional language, and it is conditional language that suggests that the occurrence itself, not just the commencement date, not the exact date, the occurrence itself is conditional and uncertain. And that qualification is not in the agreement between Medallion and Epic, but it is in the agreement between Medallion and ARM, and that shifts the risk to ARM. We also see on the next slide that there was the expected to be language that was added to the commencement date provision in between Medallion and ARM. The expected to be language is not in the agreement between Epic and Medallion. The agreement between Epic and Medallion gives a seemingly firm date, but that is not in the agreement with ARM. The agreement is different, and it shifts the risk to ARM. ARM would rewrite this definition to make the commencement date mandatory by saying which shall be by June 1, 2020, instead of expected to be. ARM agreed to pay the same amount per month, regardless of whether the new terminal opened, and knowing that its right to nominate for loading at the new terminal was subject to the commencement date of the new terminal, even occurring. Now, ARM argues that there is a mismatch between the pipeline capacity and the loading capacity of the initial terminal. And this mismatch argument is basically the foundation of ARM's argument that it mattered that it have a right to nominate to the new terminal, even though it already has a right to nominate the initial terminal, and it only gets one nomination window per month and pays the same amount per month regardless. It would be true that there would be a mismatch if ARM or Glencore had ever used the full pipeline capacity. They have not shown that they did. In other words, they have not shown that they needed that new terminal. In fact, the evidence shows that in many months, they did not use the pipeline capacity.
So there was an argument made in the initial opening or initial closing that during the course of this contract that pump over fees were paid by ARM. Is that correct?
Right. There's absolutely no evidence of that.
There's no evidence of that. Okay.
No evidence of that
Then
whatsoever.
I'm going to want to hear in rebuttal what the evidence is of pump over fees.
Okay. Glencore did pump over crude oil to other terminals, but they had access to other terminals. There's a lot of options at this port. Glencore did a lot of pumping over to other terminals. There's no evidence that they did it because of any limitations with the Epic terminal. And in fact, Mr. Freshwater's testimony would suggest that Glencore was loading the same size ships at the other terminals that it was loading at the Epic initial terminal. ARM introduced a couple of emails from 2019, which was prior to contracting, talking about a mismatch between pipeline capacity and terminal capacity. Nothing made it into the contract to address that issue. There's nothing in the contract about loading a Suez Max. There's nothing in the contract about a mismatch. In fact, the mismatch, if there is one, is created by the words of the contract itself, which was negotiated by ARM's team of lawyers. The 2019 emails about a mismatch are simply irrelevant. When a contract's meaning is disputed, the primary objective is to give effect to the intent as expressed in the instrument, of course, and if language about a mismatch between pipeline and terminal capacity didn't end up in the agreement, then the intent of the parties was that it's not be in the agreement. Your Honor sustained some parole evidence objections and overruled others, but the parole evidence rule is obviously not just an evidentiary rule. It is a substantive rule of contract construction, and it is particularly robust in this type of case where you have sophisticated oil and gas companies represented by counsel and arm's length transactions. And it also matters that the written contract, if we could go to the next slide, contains a recital that contains the entire agreement between the parties or a similarly worded merger provision. And these agreements have strong merger clauses. And of course, a breach is not enough. Under the Terminal Services Agreement, as under the Transportation Services Agreement, a breach must be material in order for ARM to have a right to terminate and seek recovery of the prepayments and credit support. We heard a lot from ARM about optionality of being able to load 1 million barrels on a Suez Max vessel, but theory isn't enough to show materiality. There is no evidence in the record about lost profits or revenues or the value, if any, of shipping on a Suez Max. Even the so-called mismatch between pipeline capacity and terminal capacity is not material. There is no evidence that ARM or Glencore lost money due to a mismatch in pipeline and terminal capacity. There are a lot of options in Corpus Christi for what to do with crude oil. There are many terminals and there are many refineries. Was Glencore paying a rate calculated based on 27,778 barrels per day of crude oil when it was not shipping that full amount? Absolutely. And that is consistent with the pipeline capacity being the valuable piece of the deal. That's why the payments under these agreements are calculated based upon the pipeline capacity. The parties assigned a value of 10% to the terminal, and the parties agreed that this was a ship or pay deal. Glencore was going to have to pay for the capacity each month regardless. And the reason I say, of course, Glencore is going to pay for the capacity each month regardless, because ARM never paid any fees under these agreements at all. All fees that were paid under these agreements were Glencore. ARM only has the prepayment and the letter of credit. So in their October 5, 2020 letter, ARM and Glencore complained about the so-called mismatch, and they claimed that customer has been assessed incremental storage fees for crude oil that is not loaded or is required to sell crude oil at the terminal or excess pipeline capacity at distressed pricing levels. ARM did not show you any evidence of any of this in this trial. ARM did not show you any storage invoices. ARM did not show you any documentation of distressed sales at the terminals. 3 days after receiving this letter, Medallion asked for documentation of storage invoices. That's Defendant's Exhibit 272. Medallion never got a response. ARM did not respond to Medallion. ARM did not show you this evidence because this evidence does not exist. There is no evidence that Glencore even used the full pipeline capacity that purportedly created the mismatch. There is no evidence that Glencore suffered any harm due to purported dock limitations. There is no evidence that Glencore had to go to other terminals due to the limitations of the EPIC terminal. The mismatch is an entirely hypothetical, theoretical problem that is kind of an after-the-fact gloss for this litigation. Under the Mustang factors for materiality, a resolution of the so-called mismatch, which is, again, essentially the same as saying resolving the new terminal issue, because ARM has taken the position that the new terminal would have addressed the mismatch that they claim existed between pipeline capacity and terminal capacity. It's not a benefit which ARM ever reasonably expected, and it would be extraordinary for Medallion to suffer a forfeiture as a result. The agreement actually says there's going to be an initial terminal and it gives loading rates and the like, but it does not say that the initial terminal will be able to load a Suez Max there in the inner harbor. It's also, a very important materiality provision from Mustang is number 5 here. The extent to which the behavior of the party failing to perform or to offer to perform comports with standards of good faith and fair dealing. Here it is, the party claiming breach, ARM, which did not behave in good faith. ARM made unsupported statements in its October 5, 2020 letter. ARM failed to provide any documentation. ARM failed to respond to Medallion's multiple letters. ARM did not respond to EPIC's February 2021 offer to pump over to Pin Oak, even though we now have heard for the first time that that was apparently the alleged breach. And all of this was used as a pretext to terminate. One of the things that ARM's counsel said in closing was that Glencore participated in termination, essentially, by assigning these contracts back to ARM and terminating the credit support, and they had no reason to do so whatsoever. Well, that's in their reason is in Mr. Freshwater's testimony. The reason that Glencore participated in terminating these contracts is because ARM couldn't get it the supply that it needed to fill the pipeline. And ARM's counsel also argued that there was no effect on Glencore of the collapse in spread. There's no evidence at all that Glencore was unaffected by the dislocations due to COVID with respect to the overseas spread. So, Your Honor, I do have some argument I would like to make on the transportation agreement, but I'd like to see if you have any other questions on the terminal agreement before I do that.
No.
Okay. So if we go back to slide 3, what did Medallion agree to in the transportation services agreement? In Article 2.01, Medallion agreed to provide committed firm service. That means priority capacity that is equivalent to the highest level of service offered or provided by EPIC Pipeline. Whether or not EPIC offered or provided WTL, ARM did not show that any other shippers received better service. That's game over. Therefore, there is no breach. You saw in ARM's closing that they put up briefly some testimony of Mr. Wishoff saying, well, committed firm service doesn't say what it says in the contract. It actually means something much narrower. There's no basis for that at all. The court should apply the contract language. ARM can't point to the tariff language to establish the contractual right either. If we look at the next slide, Medallion's tariff says that it will accept crude petroleum for transportation under EPIC's Permian Common Stream 1 and Permian Common Stream 2, pursuant to the quality specifications of the EPIC Rules and Regulations tariff. EPIC's quality specifications, which are the 3-page Exhibit B at the end of its Rules and Regulations tariff, say that the gravity, and the gravity is the quality of the crude oil that makes it WTI or WTL or something else, the gravity must be readily amenable for transportation through the carrier's existing facilities, the facilities that are actually there, and will not materially affect the quality of other shipments or cause disadvantage to other shippers and or the carrier. In other words, EPIC itself. Arms counsel said in opening several days ago, last week, that a tariff has profound implications. And that is true. EPIC has duties to all shippers, and those duties must be balanced. It is uncontroverted that EPIC could not accept WTL and get it to the coast as WTL without commitments from shippers that are equivalent to a segregated batch. Doesn't mean that one shipper is asking for its batch to be segregated, but just mechanically, you have to have about 100,000 barrels to do that. And it is uncontroverted that shippers never provided that from April 2020 to April 2021. Arms counsel, in closing just now, argued that a tariff is just a floor. You know, you can do more than what's in the floor. Well, if it's a contractual document, Your Honor, then the floor is all that EPIC is required to do. But moreover, there's no evidence at all that EPIC could offer service to one shipper and not offer it to others. It's kind of the nature of a common carrier pipeline. It's a little bit like a utility. A crude oil pipeline cannot treat a tariff as being merely a floor. EPIC made this even more clear on December 1, 2020, when it amended the quality specifications to expressly provide that due to prevailing operating conditions, carrier does not currently offer service under this common stream, and Medallion did not have an obligation to provide WTL service when that service was not offered or provided by EPIC Pipeline. As with the terminal, Medallion also did not have any duty until ARM makes a nomination. ARM's counsel said in opening that ARM was told repeatedly by Medallion about WTL, do not nominate it, we will not accept it. ARM offered not one bit of evidence in support of that assertion. To the contrary, EPIC wanted to ship WTL. I asked Mr. Burney of EPIC if ARM or Glencore had come to EPIC with a significant supply of WTL and a desire to ship it to the Gulf Coast, would EPIC have wanted to ship it? The answer was 100%. Now, there has to be a nomination. Medallion's tariff says that a shipper desiring to offer crude petroleum for transportation shall make a nomination. And as we discussed earlier, Glencore's first nomination for WTL transportation was December 22nd, 2020, after the monthly deadline for nominations, after WTL service was removed from the EPIC's product specifications, and from a common carrier that Mr. Wishoff again confirmed this morning did not itself offer WTL service, that being Delaware Crossing. Mr. Wishoff admitted in his testimony that this nomination was a legal decision and was, in his words, quote, a bit frivolous. A sham nomination like this does not require performance by Medallion, because shipping different qualities of crude oil on the same pipe is not like ordering the 3-meat plate at Dickey's. It is a very complicated process with a lot of moving parts. There's one pipe. You heard from Medallion's CEO, Mr. Lentz, who's the only witness you've heard from who has a career in pipeline operations. And he explained that when you are moving one grade of crude oil, then you are not moving another. It's like directing traffic. And it is why EPIC's quality specifications allow EPIC to reject crude oil when shipping it would cause disadvantage to other shippers or the carrier. EPIC has and must have a lot of discretion to manage its pipeline to the benefit of all the shippers, since it is required to do so as a common carrier. The Transportation Services Agreement does not give ARM a contractual right to WTL service on connecting pipelines that come into EPIC. There is, in fact, there is no dispute that there was not a connecting pipeline with WTL service from April 2020 to April 2021. I believe we confirmed that with Mr. Wishoff also this morning. Mr. Burney's testimony about it is unrebutted. There's no dispute that truck loading was not feasible, that loading WTL from a truck location would take hundreds of trucks and eat up any expected profits. If ARM cannot get WTL to the EPIC pipeline, that is not EPIC's or Medallion's problem. Mr. Wishoff admitted this, if we look at the next slide, that EPIC did not control the tariffs of the interconnecting pipelines that did not offer WTL service. It's not EPIC's fault that ARM could not get WTL to an origin point for shipment. There's no question that EPIC wanted to provide WTL service. As Mr. Burney's testimony shows, EPIC invested about $200 million to make that happen. ARM's counsel argued this afternoon, well, we just don't know why they didn't ship WTL. It is all in there in Mr. Burney's testimony as to why they were not shipping WTL. His unrebutted testimony shows that there was one origin point that was supposed to provide the WTL supply, and that was Salt Creek at Orla. EPIC built all the way from Crane to Orla specifically to carry WTL. WTI would be coming down from Wink and from other origin points that I've left off this chart for simplicity. At Crane, EPIC was going to have to be the traffic cop, stopping WTI so WTL could go by, and vice versa. But there is no dispute. There's no WTL coming down this pipe from Orla because Salt Creek's pipeline connection into EPIC at Orla was not in service during the time period of April 2020 to April 2021. Mr. Burney's testimony shows that the lack of a connection between Salt Creek and EPIC at Orla was Salt Creek's fault, not EPIC's fault. There was no connection because Salt Creek had not figured out how to manage its own quality stream so that it was flowing WTL instead of even lighter crude oil called condensate. Mr. Lintz's testimony also shows this. He met with ARM folks who were managing Salt Creek, including Mr. Wishoff, in the fall of 2019, and the ARM folks didn't have a plan to deliver a consistent WTL stream. And so as Mr. Burney testified, once the physical connection was made between EPIC and Salt Creek at Orla in June of 2020, there was still no WTL because Salt Creek couldn't supply it because their crude oil was too light. And as a result, they did not could not make that connection, and EPIC had to spend months trucking in line fill from Rio. On the issue of line fill, ARM made a remarkable statement in its materiality brief yesterday. ARM said that Medallion's bizarre suggestion that responsibility for lack of WTL line fill lies with ARM's affiliate, which manages Salt Creek gathering system until July 2020, is unfounded. Salt Creek timely supplied its required line fill for the EPIC crude pipeline. ARM cited Mr. Burney's deposition, 2291 to 2397, a 10-page spread. ARM should have mentioned the questions right after that, 239, 8 through 14, where Mr. Burney testified about the role of VTOL, which was assigned the contract from Salt Creek. Did they provide the line fill from Orla? No, they did not. They provided line fill, but not for that line from Orla that was going to have the WTL. Contrary to ARM's representations to the court, Mr. Burney made it crystal clear that responsibility for lack of WTL line fill lies with ARM's affiliate. The line fill responsibility does not lie with Medallion, because Medallion was not required to provide line fill by Epic. That is in Article 3.7 of the Reciprocal Capacity Lease Agreement, which is Defendant's Exhibit 19. That is essentially the equivalent of the Transportation Services Agreement, but between Medallion and Epic. And that provision says that Medallion will not owe any line fill on the Epic pipeline. Now, the Epic tariff, which is, and Rule 12 specifically of the Rules and Regulations tariff, Defendant's Exhibit 10, says that the shippers are going to provide the pro rata share of line fill, all right? So 500,000 barrel pipe, a small amount of that pipe is this 27,000 barrels of capacity. That whole pipe has to be filled with line fill. So there's this little piece here, and that question is whose responsibility is that? And that is Epic's responsibility. In the agreement between Medallion and ARM, it says Medallion will supply any required line fill. There was no required line fill from Medallion because it would have been due from Epic, but Epic never got to that point because none of the other shippers, most especially Salt Creek, had WTL to fill the line. The Transportation Services Agreement, it doesn't matter regardless whose fault it was that Salt Creek was not flowing in Epic at Orla. The Transportation Services Agreement gives a right to flow crude oil into the Epic pipeline only at in-service origin points. The agreement between Epic and Medallion has a form local rates tariff attached showing origin points. The Orla origin point is shown as TBA to be announced. There is no form local rates tariff in the Transportation Services Agreement between Medallion and ARM. ARM had no contractual right to a Salt Creek Orla pipeline connection. This is another example of how the agreements between Medallion and Epic are not exactly replicated by the agreements between Medallion and ARM. Where Medallion doesn't have control, the risk is shifted to ARM. If we move, Your Honor, to just some more general remarks, kind of about what was happening in the market at this time. First of all, with respect to the terminal, there is nothing in evidence where Glencore ever nominated a Suez Max, and ARM must be ready, willing, and able to perform in order for there to be a breach, and that breach has to be material. And what happened here was that ARM's CEO, ARM's business strategy backfired. ARM's CEO, Mr. Lee, Zach Lee, gave an interview in August 2019, and he explained ARM's strategy. ARM has the interview on its website to this day, and if we can look at it on slide 59. Mr. Lee said in this interview, we overbuy optionality and we overbuild our options. That's what happened here with respect to both the pipe and the terminal. ARM bought the capacity without having the supply to fill it. Your Honor, to the extent that there was not, that ARM did not have crude oil supply, that also affects the materiality of its terminal argument as well. Because Mr. Freshwater testified that it was ARM that was supposed to fill this capacity on the pipe, and ARM could not do so. Mr. Lee, this interview is from August 2019, so it's very close to the time of these agreements. And Mr. Lee is out there. He wants to buy up capacity, overbuy, overbuild, and then fill up the supply later. And in fact, Mr. Lee provided in this interview an example of of exactly what he was trying to do. He said, for example, we'll take out capacity of 100,000 barrels a day at a certain rate, but we're not the anchor on a long haul pipe, say coming from the Bakken. Now, 100,000 barrels a day might be a $1 rate, but a 5,000 barrel a day producer can't do that. His rate might be $2 a barrel. So we'll aggregate all the producers that are our customers and say, let's ride on this lower rate together. This strategy does not work if the price of capacity plummets after you've bought it, so that your rate is the highest one out there. ARM would be upside down on the rate because even the small producers could get a much lower rate anywhere else than with ARM. And that includes, Your Honor, not just with the pipeline capacity, but with the terminal capacity, because we looked at, there's an exhibit which is an August 2020 email from Glencore that said that the terminal capacity was also trading at 1/3 of the price. ARM contracted to take the risk of collapse of the price of the pipeline capacity. ARM contracted to take the risk of collapse in the price of the terminal capacity. With respect to the new terminal, Your Honor, you had asked a few questions about the state of the new terminal, and there is some testimony from Mr. Burney in the record about that. Epic got to 60% completion on the new terminal, spent $60 million. It's a suspended building. There's no evidence that Epic will not resume construction when there is demand for it. And I think that the demand issue gets at what was happening here and why Mr. Lee's strategy backfired. He bought into a maelstrom, which was COVID, and there simply wasn't demand to fill the pipe or to fill the ships. This capacity, Your Honor, on the Epic pipeline compensated Medallion for unreimbursed capital costs and for giving up its own capacity to Epic. Because ARM agreed to provide credit support, Medallion did not do a deal with Macquarie, and Medallion did not take the $69 million option from Epic. Medallion's damages reflect two facts. The first fact is that ARM's credit assurance did not secure Medallion for 100% of the amounts that would be due to Medallion under the contracts. Medallion can't recoup all of the money. And the second is that Medallion can't recoup all of the money in mitigation because his capacity is still not as valuable as it was when ARM agreed to pay $1.50 per barrel.
So, Mr. Carter, I want to make sure that I understand what you're saying is, if I find there is a breach, then the proper measure of damage would be 32.7. Correct? There is no offset to that.
Yes, Your Honor.
Okay.
Right. Yeah, it is. It's one or the other, and so that's why I was transitioning. At this
It's
point
not a great position. I don't love that that's my only choice if I find there's a breach, but that is what I think both sides agree that's what the contract says.
Yes, Your Honor.
Okay.
The amount due from the ARM under the contracts is calculated as follows. We start with the pre-termination fees. This is a short period of time before Medallion terminated the contracts in April of 2021. It's about $169,000.
30 minutes left.
Thank you, Your Honor. And then we go to the future fees, future as of the date of termination, which is the $68.5 million for fees that ARM owed for the rest of the term of the contracts after termination. These future fees, as of April 5, 2021, have to be netted to the date of termination. The terminal services agreement specifies an interest rate for that purpose of 10%. The transportation services agreement does not specify an interest rate for that purpose. And since this is a fixed income stream, the interest rate should be relatively low, 3 1/8%, as Mr. Pulliam testified. So that gets you to $63,635,000 on the total post-termination fees. We then need to subtract out the prepayments, which is $13,700,000. One of the major ways that ARM tries to reduce Medallion's damages is by giving itself 10% interest on the prepayment amounts from when they were paid in August 2019 to when Medallion terminated, which is April 5, 2021. The contracts have no provision for ARM earning interest on its money. And so that can't be read into the contracts. We also have to subtract out the letters of credit. And we need to subtract the mitigation that Mr. Witt testified about. No rate is specified in the agreements for discounting the mitigation to the date of termination. But the interest rate for mitigation in Mr. Pulliam's analysis is higher than the interest rate for the net present value of the future fees, because this mitigation has for most of this time been a month-to-month and uncertain process. ARM has put Medallion in the position of going from having a fixed income stream to having to go out and try to market this space month to month in a down market. The result is total damages to Medallion on the transportation services agreement of $8.1 million, plus prejudgment interest of $683,000, to make a total of approximately $8.8 million. And the total damages to the Medallion on the terminal agreement are approximately 3.84, plus prejudgment interest of $342,000, for a total of about $4,188,000. Your Honor, we have talked about ARM Energy Management, but we haven't talked about the fact that the word ARM is actually an acronym. It's an acronym for Asset Risk Management. ARM is a company that bills itself as managing risks. Zach Lee, ARM CEO, talked about Mr. Wishoff's optimization group's management of risk in his August 2019 interview. The article describes how the optimization group takes capacity on a pipeline or leases storage space, then aggregates production from several of its smaller E&P customers that otherwise might not have the ability to secure such capacity on their own. And then Mr. Lee says, we step into the market for them and we take risk on their behalf. Mr. Lee was especially proud of how ARM took the risk of pipeline capacity from the Permian Basin to Corpus Christi. He said, as producers get to a certain size and keep growing, they're asking us for more, and they're asking us to put our balance sheet to work. We're trying to be accretive and step into the risk on their behalf. I feel we have to bring something to them and not just be a third-party vendor. If we own capacity to Corpus Christi, then that's something we can provide that maybe not everybody else can provide. If you take on risks, you sometimes can make money. ARM's counsel asked Mr. Wishoff for an example of how ARM takes advantage of optionality to make money. Mr. Wishoff described how ARM made money through selling natural gas back into Texas during Winter Storm Uri. ARM made money off of a surprising event, but risks don't always work out. And surprising events such as COVID can be very unfavorable. ARM stepped into the risk of having pipeline capacity to Corpus Christi and terminal capacity at the dock. Unfortunately, like a lot of business bets made during COVID or before COVID, this one turned out to be a loser. But as between ARM and Medallion, ARM agreed to take the loss from the bad bet, just as it would have taken the benefit if the capacity had increased in value. Medallion asked the court to enforce the contracts, grant judgment in favor of Medallion and against ARM, and award Medallion's full damages. Thank you, Your Honor.
Is that it?
I'm giving you back some time.
Great. All right. Let me just talk to you guys about the rebuttal, what I really want to hear argument on, and it's really 2 points. One is on the pump over fees. There seems to be a disagreement on whether or not there's evidence of pump over fees, which is important to me. And the second issue is simply what is the materiality of the Suez Max, the breach. You probably already guessed this from my questions. I think there was a breach of the Suez Max agreement. The question to me, and I've kind of leaning in one direction, but was that breach material? So those are really the 2 main arguments I need to hear.
Can we have a quick break?
Oh, do you want a break, or do you want, Mr. Stern, are you ready to finish?
I would like a quick break if we could, just so we could get our thoughts organized. There are different voices here, and I just want to make sure that we're addressing the court's questions efficiently.
Okay, we'll take a 10-minute break.